President Donald J. Trump has reignited a long-standing controversy by publicly demanding that the Department of Justice conduct a formal investigation into Senator Richard Blumenthal of Connecticut. This latest salvo focuses on allegations that Blumenthal misrepresented his military service during the Vietnam era, raising critical questions about material misrepresentation that transcend legal boundaries and probe ethical accountability in public office. Senator Richard Blumenthal served in the United States Marine Corps Reserve from 1970 to 1976, achieving the rank of sergeant. Crucially, Blumenthal was never deployed to Vietnam or any combat zone during this period.
We have learned something very important since the days that I served in Vietnam, and you exemplify it. Whatever we think about the war, whatever we call it, Afghanistan or Iraq, we owe our military men and women unconditional support. Since the days that I served in Vietnam,
His service was conducted domestically, stationed in units based in Washington, D.C. and Connecticut, undergoing training and performing reserve duties. Despite these facts, on several known occasions, Senator Blumenthal publicly suggested he served in Vietnam, resulting in intense scrutiny and political fallout. At a veterans ceremony in 2008, Blumenthal remarked, "We learned something since the days that I served in Vietnam." This and similar statements at political rallies, public speeches, and veterans events created the impression that Blumenthal personally served in combat theaters of the Vietnam War. His 2010 Senate campaign, The New York Times, published an exposé highlighting these discrepancies, citing video and transcripts of multiple occasions where Blumenthal made similar claims. In response to mounting criticism, Blumenthal issued statements acknowledging that he misspoke on a few occasions. He clarified publicly and repeatedly that he served during the Vietnam era, rather than in Vietnam itself. During a 2025 CNN interview with Caitlin Collins, Blumenthal admitted, "I served in the reserves, and I referred to my service in Vietnam on a handful, just a couple of occasions, rather than during Vietnam." He further issued an apology, emphasizing that his record of service should have been described with clarity and precision, expressing regret for any confusion caused by his remarks. The legal dimensions of this controversy hinge on whether Senator Blumenthal's statements represent material misrepresentation actionable under federal law. Several statutes and judicial precedents are relevant. False statements. 18 U.S.C. Section 1001. This statute criminalizes knowingly making materially false or fraudulent statements in any matter within the jurisdiction of the executive, legislative, or judicial branch of the government of the United States. Successful prosecution requires proof of knowingly false intent and materiality. Stolen Valor Act, 18 U.S.C. Section 704, 2013 Amendment. This law criminalizes knowingly falsifying claims to military medals or honors when done to obtain money, property, or other tangible benefits. However, the Supreme Court ruling in United States v. Alvarez, 567 U.S. 709, 2012, invalidated broad prosecution under the original statute, holding that the First Amendment protects many false claims absent fraudulent intent or material benefit. Uniform Code of Military Justice, Article 107, governs false official statements by active duty military personnel but does not apply to elected civilian officials such as Blumenthal. State campaign and election laws. Some states, including Ohio, Section 3517.22, regulate knowingly false campaign statements intended to influence elections. These statutes typically empower election commissions to adjudicate such matters, although enforcement is rare and constitutionally fraught. Claims of false military service are often met with heightened political and media scrutiny, especially among Vietnam-era veterans, who historically faced neglect and public indifference upon return from Southeast Asia. Because of this, misrepresentations or exaggerations are particularly inflammatory and carry strong pejorative labels such as stolen valor, indicating perceived theft of legitimate veteran status. This distinction from Blumenthal's case is important. While his statements have been described by critics as misleading or inaccurate, no legal authority has substantiated evidence that he sought to gain material benefit from such statements. His defenders highlight his consistent public support for veterans' causes and an otherwise unblemished military record as evidence of good faith and honorable service. President Trump's recent public calls for a DOJ probe arise from a long history of political antagonism between the two figures, periodically fueled by Blumenthal's vocal criticisms of Trump's policies and conduct. Trump's rhetoric underscores the potential reputational damage and political leverage gained by questioning an opponent's military credibility. While criminal prosecution under the current legal framework appears unlikely, the controversy invites broader ethical questions about truthfulness, transparency, and accountability in political campaigns and governance. Congressional ethics committees and state-level campaign commissions may review instances of misstatements, but their jurisdiction is distinct from judicial proceedings and tends to focus on public censure rather than criminal penalties. Voters and political parties ultimately serve as gatekeepers for accountability through electoral processes, especially where formal legal mechanisms prove insufficient or inapplicable. Senator Blumenthal's admitted misstatements about serving in Vietnam versus during the Vietnam era have fueled sustained political controversy. Despite Blumenthal's apologies and clarifications, President Trump's renewed demand for a federal investigation highlights enduring tensions between legal standards, political truth, and electoral accountability. Given the protections enshrined by the First Amendment and interpreted in United States versus Alvarez, criminal prosecution hinges on clear evidence of fraudulent intent or tangible personal gain, criteria not currently met in this case. The ultimate resolution of this issue rests with ongoing political judgment, ethical oversight, and the will of the electorate.